My name's Keith Carlson, and excited to be here again. We're going to take a look at what just was and what might be in the Supreme Court recent term and upcoming decisions. You probably have already heard from and know well one of our distinguished panelists, Dr. Eastman, so I won't spend much more time on his bio. Just pointing out a little conversation we were having. It amazes me how quickly the stores get the Constitution Day decorations out. It's like 4th of July is over. And so John and I were scrambling, decorating the house last night. We're kind of honing in on Article 6 this year. At the prior debt stuff is a lot of fun for the kids. And it was a Millard Fillmore year for President's Day, because you got to pick one. You can't celebrate them all. So we're going to hear from John in a little bit. We're going to hear, last year we were really talking quite a bit about the administrative state, and kind of got some neat stuff to talk about, well, interesting stuff to talk about, and see where we stand on that battle. I also get an opportunity to hear from Professor Muller, who's really focuses in on election law and teaching at Pepperdine, and some important issues regarding federalism. And there is, let's just get going without any further ado. John, I think we're gonna kick things off with a look at some deference issues, and I'd be curious, just weaving in how this is going to impact what we were talking about in this panel just last year. The status of the battle, how it goes with the administrative state. So with that, let's turn it over to Professor Eastman. Thank you.
Thanks, everybody, again. I hope it was a nice lunch, and I hope many of you saw the Freedom Plaza and the piece of our Berlin Wall. It's a wonderful space on campus. Last year, we talked a lot about what I was anticipating to be some major development in administrative law, particularly on deference doctrines. The court, for the first time in decades, had taken up a case dealing with what they call the non-delegation doctrine. This is one of those hyper-technical, buried deep in the Constitution issues. It's in Article 1, Section 1, Clause 1 of the Constitution. The legislative powers herein granted are vested in Congress. And that means Congress has to make the laws. They can't pass that duty off to an unelected bureaucracy. They can't pass it off to private actors. They have to be the ones that make the tough policy calls. And increasingly, they don't do that. The court came up years ago with a theory of how we could allow delegations of effective lawmaking power to these vast regulatory agencies, as long as Congress made the hard policy judgments and gave to the agency an intelligible principle that would confine their discretion in how to implement that policy judgment. But over the years, as a couple of major opinions from Justice Thomas issued over the last few years have pointed out, that intelligible principle doctrine was really no doctrine at all. They've upheld as intelligible principle delegations of lawmaking power to the Federal Communications Commission to regulate the airwaves in the public interest. The Securities and Exchange Commission to regulate the markets to prevent unfairness. These are no principles whatsoever, much less intelligible principles. And you can go through most of the delegations of rulemaking power to the various alphabet soup of agencies. I've often wanted to get one of those Powerball bowls and pull out 4 or 5 different letters and see how many different agency names I can make by mixing them up. But they always have these problems. Anyway, so there's a case that was the Supreme Court granted last year called Gundy versus United States, where the Congress had wanted to pass a law requiring sex offenders to register, all right? The Sex Offender Registration and Notification Act, SORNA. But there was actually a dispute on whether they could apply it retroactively to people who had previously been convicted of sex offenses, or whether they could apply this registration requirement only prospectively. And they decided to punt to the Attorney General and said, you figure it out. You decide whether it ought to apply retroactively or prospectively. And Mr. Gundy was a existing sex offender. I don't remember even what his crime was. It might have been a 16-year-old kissing a 15-year-old. I don't know what it was. But he said, you can't do that. You've given the Attorney General the ability to make law without any intelligible principle. His cert petition in the Supreme Court had 4 different questions presented. The fourth of them was, does this delegation of authority violate the non-delegation doctrine? Right, which is music to my ears. I mean, as you know from last year, we were kind of the point of the spear, the tip of the spear on pushing these doctrines and urging the court to take them up. The court denied review on the first 3 questions and granted cert on that 4th question. Did this violate the non-delegation doctrine? I'm jumping up and down. We lost 5-3. Now, and I'm still jumping up and down, and let me explain why. Justice Kagan, joined by Ginsburg and Breyer and Sotomayor, wrote the majority plurality opinion. They were joined only in the judgment by Sam Alito, who's on record, along with Thomas, as being a strong defender of reviving the non-delegation doctrine. So what the heck's going on? Here's the issues presented squarely, and he sides with the left? What's going on? Well, a little inside baseball here. Justice Kavanaugh was not sitting yet because he had a little hiccup on the way to confirmation. Was not sitting yet. This was argued the first week of the term, all the way last October, and he wasn't sitting, which meant he couldn't be voting on the case unless they just hold it for re-argument. So there are only 8 justices. If Alito sides with the 3 in dissent, we get a 4-4 decision. And what happens with a 4-4 decision? We don't get any opinions at all. We get one line out of the court saying the decision of the lower court is affirmed by an equally divided court. We don't get Justice Neil Gorsuch's thorough, expansive, scholarly, dissenting opinion outlining why the non-delegation doctrine has to be revived, that is such a core aspect of separation of powers. Justice Alito's concurrence in the judgment says, when we get a majority of the court that can actually confront this issue, I'm siding with them. But we don't have it right now, so I'll cast my vote to keep it in. Oh, that means assuming Justice Kavanaugh now is with them, and his experience on the D.C. Circuit, as you heard from Judge Sentell earlier today, the D.C. Circuit deals with these non-delegation doctrine issues quite a lot, and Justice Kavanaugh was leading the charge on those things while he was on the D.C. Circuit as well. If he is where we anticipate he will be, we've got 5 votes to revive the non-delegation doctrine. And to start saying, Congress, if you want the economy regulated, you got to make the hard calls, the policy calls, the judgment calls, the balancing tests. You can't pass that off some unelected, unaccountable bureaucrat and then claim, we've solved the clean water problem. Hey, it's not our fault, the trillions of dollars it's now costing you and the job loss or whatever. You've got to make the hard calls. Now, one question. Well, if that was the issue, and we have really 5 votes, why didn't they just reschedule it for re-argument like they did with a couple of other cases heard that first week? And I'm thinking here there's a little political prudence being played out by Justice Alito, maybe by the others. Do you really want the non-delegation doctrine to be revived on a sex offender registration case when Justice Kavanaugh is the deciding vote in his first year on the court after what he just went through? Probably not. But I'm very encouraged that this issue now is so front and center that it looks like we have 5 votes. The other big of the deference, the administrative law cases, was an old case called Auer deference. And I think I talked about this one last year too. And Scalia was the author of Auer deference, and shortly before he died, he said he made a mistake, and he would overrule it at the first opportunity. Well, we had another case up there this term called Kaiser versus Wilkie, where the question presented was, should Auer be overruled? This is deference to an administrative agency's interpretation of its own ambiguous regulation, which was itself an interpretation of an ambiguous statute that shouldn't have been delegated to them in the first place. And you can see why Scalia, at the end of his life, said, we got to overturn this and correct this mistake of mine. Kaiser versus Wilkie decided 9-0 Justice Kagan writing, it doesn't overrule our. So here's another loss on the term, and yet I'm still jumping for joy on this one as well. Because what Justice Kagan did with the support of the whole court is put so much teeth into the first step of the analysis under our deference that we're virtually never going to get to the agency, the deference to the agency in interpreting ambiguous regulations. In other words, we're bringing back a rather rigorous constitutional textual interpretation of following what the text means and figuring it out using all the normal tools of statutory construction. And once I've gone through that process, there's almost nothing left that would be ambiguous enough to even raise the deference issues. So we didn't get rid of our, but we so confined it as to significantly move the ball forward. And let me just show you how this plays out in real life with another case. This is a case called Weyerhaeuser versus U.S. Fish and Wildlife Service. And this greater devotion to actually applying the text as written and figuring out. So the Endangered Species Act has a provision that if, you've got to protect critical habitat of endangered critters. And the EPA or the Fish and Wildlife Service gets to designate critical habitat. And you can't do things to that habitat that will make it impossible for the critter to survive. But what they did in the Weyerhaeuser case in the lower courts, and what the Fish and Wildlife Service did, is take away from Weyerhaeuser tens of thousands of acres of property that wasn't even capable of being habitat for the critter that was being protected. But if they spent, $500 million, they could reconstruct the place and make it habitat. And the court here, with this newfound devotion to actually sticking with the text, said the text says critical habitat. That means it's got to be habitat. It's got to be habitable. Not might be made habitable. It's got to be habitat. And so, the notion, what we see here is a transformation going on. And it's not a transformation of, like we had talked about at lunch a little bit on the Citizens United case, where the change in personnel on the court caused a transformation, Alito replacing O'Connor in that instance. This is not a transformation that is occurring because Neil Gorsuch replaced Scalia or Kavanaugh replaced Kennedy. This is a transformation on the court itself realizing the error of those old doctrines as they played out. The old doctrines came up as a reaction to the old Warren Court of the 1960s. Judge Santel and I may be the only ones here that remember the 1960s like that. Yeah, I can't remember either. Things were very good in those days. My kids learned when they became teenagers and start reacting against you. I got my old Grateful Dead shirts out so they would react in the right direction. It worked, but then I had to explain what the Grateful Dead concerts were, and I practiced if I ever got nominated for a Senate confirmation post, I practiced my line. Remember Bill Clinton? He smoked, but he didn't inhale. Well, I attended Grateful Dead concerts, so I didn't smoke. I inhaled, but I didn't smoke. I think is. Now I've completely lost the train of where I was going with that story.
I think we were talking about the Supreme Court.
Yeah, the Warren Court of the 1960s was taking these ambiguous statutes, and they were making all the basic policy judgments themselves by the independent judiciary making law without any accountability whatsoever. And so the Nixon administration, administrative law lawyers like Antonin Scalia and like a lot of others said, theoretically, if we put those decisions into at least the nominally politically accountable branch of the executive, where the president has to face election, this would be better than the unelected judiciary making these legislative judgments. It sounded good in theory. In practice, it didn't work. And they have now realized that it's a violation of the lawmaking power, separation of powers, Article 1. It's also giving interpretive authority to the unelected bureaucrats in the agency, so a violation of Article 3. And they've come to this realization themselves. So this isn't because of the personnel change. Kennedy, in his, one of the last opinions he did before he retired, says we've got to revive this. We've got to address the non-delegation doctrine, and we've got to get rid of Chevron deference. These things are fundamentally altering separation of powers. So this isn't Kennedy's replacement to doing this. This was an invitation from Kennedy on the way out the door for the court to do it, just as Scalia had done the same thing. I think it's a profound transformation that is underway, and we'll see how far it runs, how much a revival of separation of powers there will be. Okay, that was the main point I wanted to get out. We've got other cases to talk about, but I'll now pass it off to Professor Muller.
Did you want to comment on the Sturgeon Frost and how it ties into this, or
Which one?
Sturgeon v. Frost? Or do you want to kick that for?
Oh, I don't remember what that
all right,
was.
all right,
So
we'll leave it.
I'll throw that in. All right, because I got it in my notes. I just had to remember.
I'll use the Eastman deference and let you just go ahead.
So, here there's up in Alaska, there's a big, 3/4 of the state of Alaska is federal land. Why that is, I have no idea. Nevada, 90%. We'll have to fix that as a longer problem. But here there was a bit of state privately owned land that was completely surrounded by national park land. And the National Park Service decided to regulate things that went on the private land. And, the court held 9-0, an opinion by Justice Kagan. Look, you get jurisdictional authority over federal lands. That doesn't mean over private lands, even if they're surrounded by federal lands. And again, just another example of this. Even Kagan and 9-0. You don't get to. We're focusing on the text more than we ever have. Kagan in her confirmation hearing, we're all textualists now. We're all originalists now. She's got a different view of those two terms than I do. But on these cases, it's becoming increasingly important to talk about the text, and not the text plus the policy plus the all of these other things, but the text, the beginning and the end of the discussion. And I think this is an extremely important development, both from reining in, what at times can be a overly activist judiciary, but also reining in an unaccountable and unelected bureaucracy. The restoration of the founder's vision of the separation of powers and the importance of that and protecting our liberty is so crucial, and it's underway, and it's exciting. And 15 years ago, you would have thought it was impossible to even begin opening the discussion on these things without getting laughed out of the room. And now it's the talk of the town, and we're on the precipice of some major victories.
Wonderful. We're going to do Q&A at the end, but just on this point, before we move on to the next kind of topic we're going to cover, for the people that aren't practicing in the area or aware, and picking up a little bit from where our conversation was last year on administrative state, how on this deference issue with respect to ambiguity does the difference arise between what would ordinarily be in contract law? Let's say ambiguity rarely goes to the benefit of the person who wrote the contract. And then you compound that here with it is the government that has all the power and should have all the lawyers it needs to write unambiguous regulations. So you kind of have two reasons that intuitively you might think ambiguity should not favor the regulators. Do we pick up any themes on that where the court might shift, and why is it so different from a private party in a contract who would clearly lose?
Well, I think the main thing, and Judge Santel remarked on this during our chat at lunch. It's a lot easier for a lot of judges around the country when you get these federal regulatory agency cases, which quite frankly aren't the most fun ones to show up on your docket. If it's one of scientific agencies, is this really necessary for critical habitat or securities and exchange, or the internet spectrum and how many bauds per second or whatever. You get all of this technical detail stuff, and boy, it's just a whole lot easier to say, hey, the agency's made a ruling here, let's defer to them. All right, it's a bit of an abdication of the judicial role to do that, and I think a lot of lower court judges, district trial court judges in particular, found it easier when the Supreme Court is starting to put teeth into those things, and I think that's important. But there was something much more perverse about this, and it was both the Chevron deference doctrine and the Auer deference doctrine and the way they worked out. Congress gets to claim they've solved the problem. We've got we had the pictures of the Erie Canal on fire, right? The water had gotten so dirty. By the way, it was a little oil tanker that spilled. It was gasoline. It burned, and it was fine. Yeah, Lake Erie. Lake Erie. You get all these things, and Congress says we've solved the clean water problem without making any of the tough calls about, or we've solved the clean air problem without having to be the ones responsible for shutting down the industry in West Virginia or whatever. Oh, that's just those mean bureaucrats. They did that. We didn't have that in mind. That's bad enough. Their refusal to take any responsibility and yet claim credit for solving the problem. But it became a corrupt coin of the realm as well. Because what they would do behind the scenes is then lobby the administrator to give exemptions for their major donors or what have you. And that kind of waiver process behind the scenes, outside the radar, became a perverse, corrupting influence in Congress. And the same thing was true for different reasons on the Auer deference, the agency deferring to the agency's interpretation of its own ambiguous regulations. If that is allowed, then the lengthy year-long process of notice and comment rulemaking to get a regulation on board, and then you get it out there and you realize it's not quite doing what you wanted it to do and you want to change it, well, if you've written it, rock solid clear, you got to go through that lengthy pain in the butt process again. If you've written it ambiguous enough that you can shift gears by just a different interpretation, you don't have to go through that process anymore. And so the incentive was built in to actually deliberately write regulations that were ambiguous, so then you could just do what you wanted whenever you wanted later on without having to go through that process again. I think those two things combined have shown the Supreme Court the dangers of these doctrines and put them on a course for serious reconsideration.
Good. Thank you for that. Derek, can you bring us up to speed on what we saw in the most recent term here, both on issues involving the political boundaries on the gerrymandering case as well as the census case that we saw some headlines on?
Sure, yeah. So partisan gerrymandering has been in the news a lot recently, right? And for the most part, federal courts have sort of been outside the process of handling partisan gerrymanders. This notion that every 10 years we are supposed to redraw the district lines for Congress, for state legislatures, and partisan gerrymandering is this notion that sometimes the legislature tends to excessively entrench itself. There's no question that legislatures are always motivated to benefit themselves. Sometimes it's a sweetheart gerrymander. They want to make sure that all the incumbents are protected. Sometimes they want to advantage themselves as a political party at the expense of others. And in 1986, the federal courts said, the Supreme Court said, you know what, the federal courts are open for business on these kinds of claims. We're not sure where in the Constitution it is. They're pretty open about that. Somewhere in the Constitution, this violates some principles of equality. And to the extent that maybe you come up with a test for us one day to figure out when the legislature has gone too far, go ahead and bring it, and we'll figure it out one day in the future. So that was 1986. And in 2004, 2005, another case comes up before the Supreme Court. Lower courts haven't really come up with a good standard in the intervening several years. Supreme Court considers it again. Justice Scalia, on behalf of 4 justices, says we never should be hearing these cases in the first place. Federal courts are no place for these classic political questions, particularly because we're still not sure what part of the Constitution addresses partisan gerrymanders. But Justice Kennedy, sort of on his own, said, you know, maybe not in this case, and maybe not today, but maybe one day in the future, we'll find the right standard to strike down partisan gerrymanders. And then last year, in a case called Gill versus Whitford, in a companion case out of Maryland, came back before the Supreme Court, and the Supreme Court sort of punted in classic fashion, saying the wrong parties brought the claim, you didn't have standing to it, you didn't raise the injuries correctly, with Justice Kennedy in sort of his a farewell address saying, you know, I just wish we could all be kind to one another and recognize that partisan gerrymanders are really bad. But this time, you know, the Supreme Court, with Justice Kennedy gone and Justice Kavanaugh now on the court, they brought a pair of partisan gerrymandering cases, one out of North Carolina in the congressional redistricting, where it was 10 Republicans and 3 Democrats. And the Republican map makers are on record saying, you know what, we think it's better when North Carolinians elect Republicans, right? So that's a pretty overt statement, right? On the flip side, in Maryland, there was a congressional map where originally it looked like it was going to be 6 Democrats and 2 Republicans. They redrew and massaged some district lines to get that map up to 7 Democrats and 1 Republican. And really the only basis for moving people around, as anyone could discern, was for that sort of purpose. when the case comes up before the Supreme Court, and the court is recognizing the same kinds of problems. Where do we draw the line? What are we supposed to be doing as federal courts drawing that line? And in particular, where in the Constitution do you have that? And so by a 5-4 decision, Chief Justice Roberts sort of essentially says the federal courts are no longer open for business in terms of these partisan gerrymandering claims. They might be bad, they might be something that we don't want, but the solution resides in the political process and saying, listen, partisan gerrymanders are not new, right? They're named after Elbridge Gerry, who was at the drafting convention of the Constitution, right? I mean, he was there then, and they were very aware of what this looked like. But Chief Justice Roberts points out that's really left to the states and then to Congress to override when it comes to congressional elections. That's what the Elections Clause is. It delegates that power to the legislature. It's not for the judiciary to decide. And in fact, we can't find a portion of the Constitution where we have it. And Justice Kagan, doing her best emanations from penumbras, sort of has a page in the opinion saying, here are all the different theories that different judges over the years have thought might be places in the Constitution where it resides, in the Equal Protection Clause, in the Guarantee Clause, in the First Amendment, in a variety of places. I think that's a real weakness of the dissent, right? We're unable to figure out where in the Constitution it says that the judiciary is supposed to intervene and sort of patrol what's happening in the state legislatures and say, you've gone too far in drawing districts. And because Chief Justice Roberts points out, look, every time you're drawing districts, it is an inherently political judgment, right? There are myriad factors at stake. Yeah, we can say we're concerned about geography and natural political boundaries, protecting incumbents, complying with the Voting Rights Act, all these things. But you can never sort of remove the politics from the political process. So by a 5-4 point, he says, look, this is not something for the federal courts to handle. It's left to the states. It's left to state legislatures. It's left to the people via ballot initiative, which happened a lot in 2018, and I assure you will happen more in the future. It happened here in California. Now, look, you might not like it in California, right? But that's the problem with the initiative process, and less so than the judicial process, right? And state judiciaries are taking this up, which might have their own problems in Pennsylvania and now in North Carolina. But there are the notion is that it's not really the federal court's business to handle these things. Now, so when it comes to 2021 and redistricting, there's going to be a whole suite of political options at our disposal, but it's not going to be left to the federal judiciary, a 3-judge panel sitting there accumulating evidence and telling a state legislature, you need to go back and redraw your maps because we don't like the outcome. So I'll briefly talk about the other sort of major election law issue, although this is a case that might be what we might call sort of a one-way ticket case, right? And that's the census case, Department of Commerce versus New York. And this is a case where nowadays the media reports are notioning that are describing potentially Chief Justice Roberts being persuaded by popular sentiment, and essentially a working of the refs and changing his mind in the 11th hour, which led to the unusual structuring of the opinion in this case. Because he wrote an opinion that sort of fractured the rest of the 8 justices in terms of agreeing with its outcome. Because the Census Bureau in the Trump administration has decided that in its new sort of handing out of the census, the major basis for sending out the census is figuring out how many people are in the United States. And you need to know how many people there are in order to apportion the House of Representatives, right? That comes straight out of Article 1. Now, one of the things we use that census data for, is to draw districts. So we apportion the House. We say you get 4 members, you get 6 members based on your population, and then we draw districts. One of the things the Census Bureau thought this time around, talking with the Department of Justice and the Voting Rights Division, is saying, you know what, maybe when we're drawing districts, we'd like to know how many citizens or non-citizens are in your district, because that affects in terms the kind of composition of voters in your district. And it doesn't make a lot of sense to draw 2 districts with 50,000 people each if one of them has 30,000 voters and one of them has 8,000 voters, because there's a significant disparity in non-citizens. And so the thought was we want to at least empower states to be able to make that decision by soliciting some of the information from the census that includes an account of non-citizens. Now, the census form includes all kinds of stuff, right? It includes your age, it includes your sex, it includes a whole variety of factors. And a lot of that is left to the Census Bureau to determine its factual judgment. This is slightly different than the legal determinations, right? In sort of a factual judgment about how it's supposed to go about its job. And so in this opinion, Chief Justice Roberts sort of walks through a challenge from New York and other states saying, no, when you do this, you're going to undercount certain segments of the population. Read, we're going to undercount non-citizens. Non-citizens are going to be less likely to volunteer that they're non-citizens on the census. despite the fact that we had a citizenship question on the census until the 1960s when it was taken off, right? So we've had a historical precedent of it. We have the Department of Justice indicating a reason for doing so. And Chief Justice Roberts walks through and says, look, this is sort of within the legal purview of the Census Department. There's a reasoned basis. It's based on substantial evidence, which is the standard to determine whether or not sort of you consider the stuff in the record. And then there's this one sort of last question. Did the Census Bureau act under a pretext, a pretextual basis? It really wanted to sort of suppress non-citizens' participation in the census. Now, the district court in this case did something unusual. It sort of solicited additional evidence outside of the record to determine the motivations of the Department of Commerce. Chief Justice Roberts says, this is an unusual thing. It was really premature to ask for this, right? We need to make some threshold finding of pretext before you start fishing around federal court, asking what the executive is doing. Good so far, right? But, and this is where maybe it's a one-way ticket. Given this record, given the evidence we have some major questions about what the Census Bureau was doing, about what the Department of Commerce was doing. And so we're going to send it back to get those questions answered. And just by doing that, just by sort of engaging in that inquiry, it was sort of enough to it got 5 votes because the 4 liberal justices joined Chief Justice Roberts in this one point. Send it back. There's a pretty hard stop date coming up shortly after the late June 2019 opinion for the Census Bureau to conclude with what its survey is going to say before it circulates it. And that was enough essentially when it sending the case back for further investigatory exploration at the district court level was enough to for the Census Bureau to give up on this inquiry. So if we took this opinion seriously, it would mean a significant revolution, I think, in how the administrative state operates, to the extent that if you believe there's sort of some pretextual political motivation within the executive, and let's face it, there's a lot of political judgments being made in executive branches all of the time, regardless of the administration. But to invite sort of additional evidence and fact-finding from the district court to sort of fish around and figure out whether or not that was your real reason or not would really grind the administrative state to a halt in most cases, as it did in this particular case. So I'm not sure. I mean, maybe
that would be good. But
maybe Professor Eastman thinks
the problem is they won't do it, right?
Yeah, right. I think it's a one-way ticket, right? In a case like Bush versus Gore, the Supreme Court never cites Bush versus Gore in the last 19 years. Lower courts might, academics like me might, a lot of folks might cite it, but it was sort of one of these one-off things the Supreme Court was going to do and never refer to it again. And it wouldn't surprise me if this is one of these situations where no one really wants to talk about what happened in this case in the future.
I'm inclined to say this on both of the partisan gerrymander cases and in the census case. It reminds me of who was the prefect of police in Casablanca. I'm shocked to learn that there's politics going on in this town. Here you're winning, sir. It's
I mean, for all of us in California, we're relieved because we passed a nonpartisan commission to draw our lines. So thank heavens we've removed partisanship in California, and look how that's working for us. This is fantastic when you take it out of there. Let's for a few minutes, let's just do maybe a little bit of lightning round on a couple of more cases before we start to look forward. John, the property rights case, Nick, I think.
Nick
was. Tell us what happened there.
Yeah. So, Nick, and let me add one piece on the partisan gerrymander cases. Justice Kennedy kept looking for a balancing test that could apply to deal with those cases. Brett Kavanaugh would not have any of that. I think the best indication of where he's going to end up as a justice is him rejecting Kennedy's search for a balancing test there. So that was good news. So the Nick case, Western Pennsylvania. There's a lot of old Revolutionary War era grave sites and what have you, and there's also just a lot of rocks. And sometimes you can't tell whether a rock is an old, broken old gravesite or not. And so the local city of township of Scott, Pennsylvania, said, we want people to be able to go through the rocks on your land to see if, in fact, it's the covering an old ancestor of theirs, and we're just going to let people basically have full right-of-way easements over your property. This gal Ms. Nick came out in her nightgown one early morning because somebody was rummaging around right outside her bedroom window in the looking for the grave sites of the old things, and she said, "You can't do this. This is a violation of my property. You've taken my property, allowed other people onto it, taken one of the key pieces of the property right, which is to exclude people I don't want on my property, and you've not given me any compensation." And the old Supreme Court rule, a case called Williamson County, said, well, the Fifth Amendment actually prohibits the taking of private property without just compensation. So until you go through a whole state administrative process, they can take your property, and if they have some mechanism for you to sue them to maybe 5-6 years later get compensated for that taking, then you really haven't been deprived of your constitutional right. And so all of these takings cases had to be brought in state court, and then by the time you lose in state court, as you inevitably did, you say, okay, now they've taken my property without just compensation. Let me go to federal court. And then the federal courts will say, well, you've already had a chance to adjudicate it. It's already decided. You don't win. And say they're completely closed from raising their federal constitutional claim in federal court. And Supreme Court reversed that and said, you know what? You can if you claim that it's taking, you get to bring it in federal court if you want. Now, that's a major advance in protecting property rights. More interesting about this case, and Professor Forte talked about it on the prior panel, so I won't talk at length about it, is they've overruled a prior precedent. And so the issue of stare decisis, there are 3 or 4 cases where they're dealing with this, and just the level of vitriol about overruling prior cases. So we can't do that, and and this wasn't even a super duper precedent; it was just a regular precedent. But they are so concerned about overruling some of the abortion cases. By the way, Planned Parenthood versus Casey overruled Roe. It overruled a whole lots of parts of Roe, and this phony language about we've stuck with the central premise of Roe. Well, we gotten rid of all sorts of things. More troubling, and this kind of goes into the broader judicial theme about judicial activism on that Planned Parenthood case, and why this willingness to overrule erroneous precedent is so important. Well, Justice Kennedy, I'm pretty sure it was Justice Kennedy, it's actually an unnamed opinion for 3, Kennedy, Souter, and O'Connor, says is the essence of our constitutional democracy is in the power vested in this court, and that we would therefore stick with an erroneous ruling specifically and particularly when the people have risen up against it, because otherwise it would undermine the legitimacy of this court. The level of arrogance, of judicial arrogance reflected in that, and the newfound willingness to revisit patently erroneous precedent because it's the Constitution under the authority of we the people that is really the supreme law of the land. That's, I think, what's going on here, and why the left that wanted to stick with every advance they get as a one-way ratchet and you can't ever question it again. They're never bound by precedent when they want to move the ball in their direction, but once they get it there, they want to lock it in as just one-way precedent. The willingness to revisit those erroneous, egregiously erroneous decisions, I think, is a very salutary development. And Nick versus Township of Scott is kind of the front end of that fight, and it's just going to get fun to watch.
Well, I wondered about that on the deference case when you were referring to even the liberals saying we're all textualists now. Doesn't that in some ways create useful tension, but tension nonetheless with stare decisis? Because if they weren't textualists then, is the decision going to stand, or are they going to follow the text? And as to the judiciary, separate point, but just to the judiciary needing to stamp down even when there's a popular uprising, it was unsigned, but I think it was Tawney in the 19th century who had a similar principle that didn't. The people still seemed to rise up somehow, and it didn't end very well.
Yeah, exactly.
What about stare decisis and this textualism movement that we might be seeing?
Yeah, no, I mean, so far they're applying this more strict textualism on new cases arising. They haven't looked at it as grounds for revisiting old things, but that's why I think Nick is so important. Nick dealt with language in the Fifth Amendment. It says if your property's taken and they haven't given you just compensation, the fact that there's a lengthy process maybe down the road where they might give you compensation doesn't mean you haven't been deprived of your your property right without just compensation at the moment, and that's a federal constitutional claim, and you get to bring it in federal court. So,
Do you think the liberal bloc, if you will, is on board with the same sort of
No.
movement or trend?
no, they see because they see where it's going.
Yeah.
They
Yeah.
see where it's going, and they don't want it there. And,
Okay.
yeah.
Fair enough. Derek, how about the Gamble case? What
So
happened there?
Professor Forte mentioned, I think, the juicy part of Gamble, but let me get the build up. So Gamble just involves guy pulled over in Alabama with a gun, wasn't supposed to have it. He was a convicted felon. He was convicted in Alabama state court, and then they tried to convict him again in federal court, right? Because it's a federal offense to be transporting a gun in interstate commerce. Maybe that's the real problem with the case, right? It's a question of whether or not the federal government has the power to criminalize these acts. But because we've construed the Commerce Clause and construed the power of the federal government broadly in these cases, a lot of convicted criminals have to sort of rely on maybe what we call second best arguments. So in this case, he says, look, this violates double jeopardy. I was already tried in Alabama. You can't try me in federal court for the same thing. My 7-2 decision of the court comes back and says, look, we have this sort of what we call dual sovereignty exception to the double jeopardy clause, which is federal and state government are two separate sovereigns. They're stacked on top of each other. And since the founding, we've sort of concluded it's legitimate for both of them to sort of have their own separate criminal codes. And for the same conduct, you can still be convicted in one court and then in another court, despite the fact there might be the sort of same kind of behavior where if they tried to do it to you for the same offense twice in state court, it might be prohibitive. So that was a 7-2 decision. The two dissenting justices were Justice Gorsuch and Justice Ginsburg for a variety of reasons. But really the juicy part of this, as Professor Forte mentioned, is that Justice Thomas sort of writes separately. He says, look, I think this is probably right. This is the right understanding of that sort of sovereignty doctrine. We think at the founding this is what it looked like. He says, but I want to have a little bit of an aside here. It's been a long time talking about stare decisis. And really, I mean, in a sense, it's irrelevant to his opinion in this case. He's not going to overturn any precedent, right? But it's this sort of long game, kabuki theater, or whatever you might say it is, about identifying stare decisis. And when he sort of lays the marker of we're looking for cases that are demonstrably erroneous, and if it's demonstrably erroneous, then we're going to overturn it. And he recognizes there are cases where it might not be demonstrably erroneous. Over the years, as James Madison points out, sometimes we sort of liquidate meaning, that there are ambiguities or uncertainties or that sort of our traditional tools of interpretation run out. And if that's the case and we sort of have a 200-year precedent on something, maybe we're not so willing to call it error if we're unable to figure that out. But if it's decidedly or demonstrably erroneous, we ought to throw it out. And that sort of solves some of the other stare decisis problems we have of these balancing tests, these malleable standards of was there reliance upon it, how significant was it, how long ago was it, all these kinds of things. So he's trying to sort of clear some of the underbrush in terms of establishing what stare decisis ought to look like in the federal courts.
Good. Between that with the gun and the Nick case, I mean, in some ways, that Nick case, it's happy it turned out to be a property rights case instead of a Second Amendment case with someone rummaging around in your backyard in the middle of the night because of state action. Yeah, it could have gone very differently, I think. John, tell us a little bit about the combo of Box v. Planned Parenthood as well as what your thinking was, the court's thinking was in the Louisiana situation.
Yeah, so a couple of abortion cases decided last term. They didn't get a lot of focus, but Box versus Planned Parenthood of Indiana, Indiana had passed a law, had a couple of provisions. One was dealing with sex or race or disability selective abortions, banning those, knowing if that was the reason for the abortion, and then also protecting fetal remains to be buried rather than just discarded with the trash. The court, it was a very odd decision. They upheld the fetal remains part of the statute by granting cert summarily and upholding that statute, and then denied review on the more substantive and contentious aspect of Indiana. Say, well, we don't have other states and other circuits that have weighed in on this particular issue yet, so we're going to punt for a while. But they're only going to be able to punt for a while. Similarly, they punted in the Louisiana hospital privileges case. There was a request for a stay of the decision and therefore block the law from going into effect. Chief Justice Roberts joined with the 4 liberal members of the court to grant the stay, blocking the law. Thomas, Alito, Gorsuch, and Kavanaugh all dissented from that. That one's coming back up, but it's back down now. That law looked a lot like the Texas law that had just been struck down when Justice Kennedy is on the court. The fact that Kavanaugh is in dissent here, I think, is rather significant. But we'll have to wait to see how that plays out. I think it's still a little too early to see where Brett Kavanaugh is going to come long term. He was Anthony Kennedy's clerk and holds him in very high regard. But these couple of cases that we've seen where he's already distinguished his views and his jurisprudence a little bit from his former boss, if you are like me that think his former boss was one of the big problems we had on the court for a couple decades, that's a very good sign.
Right. Okay, last but not least from this term, Professor, can you tell us a little bit about the Tennessee wine case?
Yeah, so this is Tennessee wine involves the infamous Dormant Commerce Clause, and Tennessee had a statute on its books that really strongly restricted alcohol sales or permits to sell alcohol. At one point, they had a rule saying you had to be a corporate resident of the state for at least 10 years before you could apply for a permit. They stopped defending that one, but the one that was at issue in this case was one that required you to be a resident for 2 years before you could apply for a permit to sell alcohol. And there's a little bit of a 21st Amendment sort of wrinkle that happens in the case. But the court, by a 7-2 decision, says, this deals squarely with what we call the Dormant Commerce Clause. So Article 1, Section 8 grants Congress the power to regulate interstate commerce. So that's a congressional power. And yet over the years, the court has recognized sort of an implied restraint on state activity, saying essentially, if you are a state that discriminates against interstate commerce, the Commerce Clause sort of lies dormant, but sort of restrains your behavior as a state. So it's not an Article 1, Section 9, or some kind of restriction placed upon the states. It's sort of embodied within the affirmative grant of power to Congress. So this is not a terribly originalist position of what the Commerce Clause indicates. As small c conservative a result it might often lead to, it's really not an originalist position at all. And Justice Alito, writing for the majority, sort of recognizes that there's not a lot of appetite on the court to overturn this, right? Justice Thomas, Justice Gorsuch sort of dissent writing about the Dormant Commerce Clause, and this doesn't make a whole lot of sense. But the majority sort of recognizes this is a deeply embodied stare decisis principle, and saying maybe there's really no other place in the Constitution that makes sense for this sort of inherent principle that we were concerned about from the very founding to exist. The dissenting justices would point out, look, if Congress views it as a problem, Congress passes a statute pursuant to its Commerce Clause authority. If it thinks a state is discriminating against interstate commerce, that's the whole point of having a Commerce Clause, for Congress to intervene. If Congress is viewed as a problem, there's no restraint on states from doing so, as bad as it might be, as negative and ill affecting on the economy as it might be. It's sort of left to Congress to do so. But Tennessee 1 is another one of these cases where it's not really an originalist position, but there are some justices on the court, or a lot of justices on the court, whose sort of appetite isn't there to sort of overturn the stare decisis principle of this doctrine that's laying on the books for an extended period of time.
I particularly like the name of the case because the leading proponent of getting rid of this Dormant Commerce Clause was Justice Thomas, and the name of the case is Tennessee Wine and Spirits versus Thomas. Anyway, so we turn to the next term?
Yeah, I mean, I thought we were putting Tennessee wine last because the cocktail hour's coming up. Yeah. Before we get there, we do need to, let's look forward. Let's look in the crystal ball a little bit, and what do you both see? A few minutes each here before we get to Q&A on what's coming down the road.
So the big three, there are two groups of three cases that are extremely big already, controlling the news on the docket. The DACA cases, whether the Trump administration can repeal the DACA guidance memo that was issued by Janet Napolitano as a matter of prosecutorial discretion under the last administration. I really. You got to understand the chutzpah of Napolitano on this. So DAPA, the parallel program, was already held to be illegal because it didn't go through notice and comment rulemaking before it was implemented. She didn't go through notice and comment rulemaking on the DACA program. She sues the Trump administration for not going through rule and comment rulemaking to repeal her DACA memo. and a DACA memo that was based on prosecutorial discretion, that the new prosecutor can't exercise the discretion in a contrary way because people have so much reliance interest on her illegal DACA program, even though her memo itself said there is no reliance interest, and every application to apply for DACA said in big letters at the bottom, this doesn't give you any statutory rights or reliance interest. They're now arguing that there's an irrefutable reliance interest from revoking it, not just for the people that had it, but for stopping to issue it on a ongoing, perpetual basis. So I'm guessing it will be at least 5. I'd like to see it be 9-0 that the president wins on this, but it'll be at least 5. He will win.
So another major question from the term is the Title VII litigation. So there's been a number of cases percolating, and it's divided the lower federal courts about how we construe the term sex in terms of Title VII and prohibitions on the discrimination of sex. So there are one series of cases dealing with sexual orientation and another series of cases dealing with gender identity. And so these interplay in a couple of different respects. First, there's no question, we're all textualists now, but everything is really anchored in textual understandings. And now there are going to be these questions about what sex means, or at least what it meant in the 60s when the statute was drafted in terms of discrimination on the basis of. And so on the one hand, there's a line of precedence from the Supreme Court saying, listen, if you sort of base it on somebody's sex stereotypes, that's a discrimination on the basis of sex. Viewing them as stereotypically masculine or feminine is sort of something embodied within sex. And so thoughts about sexual orientation or gender identity, a lot of proponents of this particular view have espoused, argue that when you have sort of stereotypes based upon somebody's gender identity or sexual orientation, that fits within sort of this understanding or this capacious understanding of the discrimination basis of sex. On the other hand, there's the argument that, listen, sex means male or female in terms of sort of what your biological identity was at birth, and that was what was understood in the 1960s, and that's the sort of definition we're supposed to use and understand, and that's the way that the statute ought to be construed today. And lurking within that is additionally, in one of these cases, it was a funeral home where somebody who had an alternative gender identity was sort of their employment was terminated because the concern from the funeral director based upon religious conviction was, listen, this is not the way to sort of operate our licensed facility, and the way to sort of console grieving individuals in the funeral parlor was based upon sort of non-traditional understandings of gender. So there's also this lurking concern within the cases about whether or not there are going to be religious exemptions to the extent that the statute is construed so broadly. So it's a major question that's been percolating in the lower courts for an extended period of time. And it's going to challenge, I think, first off, sort of these traditional statutory interpretation questions, and second, sort of a question about religious identity that exists sort of beyond that.
And then let me close with the last 2 cases that I think are very interesting. One, the Supreme Court just resolved last week by issuing a stay of Judge Tiger out here's nationwide injunction against his new rule on asylum seekers. If you want to claim asylum as a refugee, you got to do it in the first country you get to. You don't get to keep going country after country till you find the one you like best. The Supreme Court blocked the nationwide injunction. That case is not yet up on the merits, but I think that's a significant development. They are growing tired of a single judge in Hawaii or Seattle or San Francisco deciding the foreign policy of the United States, contrary to the elected president of the United States. And I think we're very close, maybe to this term, seeing them address full-heartedly the nationwide injunction. The other one is a Second Amendment case. It may go away, but it's just a peculiar case. New York has a rule that if you have a gun, you can't transport it, even if it's licensed, locked, and unloaded, to a shooting range outside of the city. Now, they don't like guns in Manhattan. You'd think they'd be happy for people leaving the city with their guns. But they're preventing you from leaving the city. They want you to shoot at things in the city, I guess. I don't know. Anyway, I think they realize they're in trouble at the Supreme Court, so New York City is desperately trying to moot the case and prevent it from being on the docket. But that was kind of fun to talk about that one, the way it's come together. Anyway, those are the couple of highlights to look for on next term, and thank you all very much.
Great. So you'll get a chance here to ask some questions of the smart guys, both the cases that were and the cases that are coming. I had a couple things as we try to get mics to the hands that are raised that maybe you can comment on. Two separate things. Trying to understand that Napolitano memo case and what seems that we've had a bit of a reversal on the Dear Colleague memo on the Title IX issues. Is there a substantive difference there, or is it just that the Department of Education predecessor didn't press the issue on rulemaking? And then I have an entirely separately related question.
Yeah, lying behind the DACA, look, DACA claimed to be an exercise of prosecutorial discretion. We're going to use our prosecutorial discretion to categorically exempt people from the deportation statutes. The Supreme Court has suggested that a categorical suspension of the law like that is not within the realm of prosecutorial discretion. But it's also been very clear, and the reason they've not resolved this issue is, where's the line, and is it a judicially enforceable line? What if I only do 10%? What if I do 20% prosecutions? Where's the line on legitimate prosecutorial discretion and suspension of the law? And I suspect that if they look at that issue, which I think they may have to do in this case, because one of the issues is going to be the legitimacy of the original memo. They're going to say that's a non-justiciable political question. We don't know how to resolve that. But there were aspects of the DACA that had nothing to do with prosecutorial discretion. Once you were in that status, you got work authorization. You got benefits. You got Social Security benefits. You got 3 years retroactive of earned income tax credits. You got all of these financial benefits that flowed, and that's no part of prosecutorial discretion. In other words, they were changing the immigration law, and that raised rather significant non-delegation issues. The other place where the non-delegation doctrine issue is coming up is Trump's declaration of national emergency for the wall, which has no confining intelligible principle for when he gets to define a national emergency or not. President Obama used it for the swine flu. Clinton used it for financial transactions with Yemen. So, Bush used it the day after 9/11. So, there are some national emergencies, but there's no defining thing. It would be wonderful to see a revived non-delegation doctrine as a result of some of those things. But the one thing that is very important is we cannot have a non-delegation doctrine that is a one-off, that it applies only to this administration but not others. When we gave the president a national emergency declaration, we didn't mean this president. That can't be what the non-delegation doctrine is. So if we are going to revive it in one of those things, I think we ought to revive it permanently.
And the other thing, looking at this term, and we've got some new faces, and we're starting to maybe pick up some trends. Have you noticed? It seems like we will have, as you mentioned, Alito kind of jumps over here, and Roberts has a couple famous times where he's jumped over. Do we have a little conservative lone wolfism happening there, or is there a little method to madness? And are you picking up any trends of where we might see kind of a block stay together versus a willingness on certain seemingly esoteric issues at times where you're going to break it and turn it 5-4 the other way?
I mean, I think there's no question that, especially because the conservatives are not monolithic. I think that they have varying degrees.
Are the liberals?
More so, not as much. I mean, but not necessarily inherently monolithic. And maybe it's that Justices Kagan and Breyer are a little bit more pragmatic or willing to sort of play the long game in certain respects and sort of creating alliances. But I think Justice Gorsuch has sort of shown himself as sort of a libertarian defender of the rights of criminal defendants, much in the mold of Justice Scalia. I think Justice Kavanaugh has had some of his own views in certain areas. I think Justice Alito, again, much more an adherent to some principles of stare decisis or some non-originalist, somewhat conservative understandings of the First Amendment, the Commerce Clause, things like that. So on some of these issues, you're going to see it. I would, I hate to call any of these cases important or unimportant, but it's probably on the more marginal cases. And in fact, this term, interestingly to me, since Justice Kennedy has left, Justice Ginsburg is sort of the third most senior justice on the court, and to the extent that there's a liberal majority or something along those lines, Justice Ginsburg, to the extent Chief Justice Roberts isn't in it, Justice Ginsburg gets to sort of assign opinion writing authority to somebody, and usually that's a powerful responsibility, and to the extent you have a powerful opinion, you assign it to yourself. But in a couple of significant 5-4 decisions, she assigned one to Justice Gorsuch and one to Justice Kavanaugh, in a sense because they were sort of the fifth vote, if you will, the swing vote in these particular cases. And in some respects, that's going to dramatically shape the trajectory of the court. If it's not Justice Kagan who's writing these criminal defendant cases, but Justice Gorsuch, they're going to have a very different tenor. So I think we see some fraying of alliances in certain cases among conservatives, but to the extent that the conservatives are writing or authoring these opinions, I think you're going to see a much more narrow and much more carefully decided in terms of originalist precedent about how these decisions might come out.
I think that's right. I want to say one thing. I continue to be concerned about Chief Justice Roberts and his considerations of what people will think of the Supreme Court and the court's legitimacy in his decisions. This became patently manifest in the two Obamacare cases. I think I agree with David Forte on the likely abortion cases at the risk of that. And so the resolution here is to make his vote irrelevant by replacing Ginsburg and Breyer in the next 4 years.
Okay. All right. Questions? In the back? We have one in the back. Do we have a mic? Oh, and then here. We'll go. Back, front. Yeah, go ahead. In the back.
Oh, what is the status of the ISIS bride case? It won't come up to the Supreme Court this term, but for you that don't know, I mean, this is an issue that Ed Meese and I started working on almost 20 years ago now. Is everybody born in the United States, no matter the circumstance, automatically a citizen? And the 14th Amendment actually says born in the United States and subject to the jurisdiction. And we're of the view that that means subject to the complete jurisdiction, allegiance-owing jurisdiction, not what they call the temporary or geographic jurisdiction. Temporary visitors, sojourners was the word they used. Today, people on temporary work or tourist visas would not be subject to that complete jurisdiction, and their children would not be automatic citizens if they were born here. This was a Yemeni diplomat working at the UN. A month before the daughter was born, he got his boss to say, hey, you're no longer working here, so that they were no longer diplomat immune, and they're clearly not subject to the jurisdiction. And they're fighting it over whether that letter meant he wasn't a diplomat, so the child's a citizen, or whether only after the State Department gets notified after she's born. Right? So there's a factual issue. But we filed a brief saying it doesn't matter. At most, he's a temporary sojourner, and she's not a citizen anyway. And what's interesting about the case is the Department of Justice taken this factual position to try and resolve the case. The judge has already indicated that he's not buying their argument. Hadn't resolved it yet, but that was the preliminary indication, which is forcing them to take our position on birthright citizenship, which, of course, the president has been urging them to do for a while. The ISIS bride, she went up, born here. She grew up after her parents managed to become citizens years later and stay. Then she went over to Syria to take up with ISIS, and it didn't work out so well for her, so she now wants to come back. And the State Department, Secretary Pompeo, is saying, no, you were never a citizen in the first place. And so I think it has the prospect of giving us, for the first time, a definitive ruling on what the citizenship clause actually means for people who are temporarily visiting the United States.
Question here in the front.
Yeah.
Then I see a hand in the back.
My question is about the Alabama guy with the gun. I think you called it the sovereignty case. And I admit the decision offends me personally. I'm not a legalist in any way. It just seems the state has so much authority. They hammer a guy, he gets off, and then they come back and hammer him again. But my question is this. What's the difference in that and me walking out on the street and being arrested in the city of Orange, and the city of Orange prosecutes me and I beat it? Excuse me, the city of Orange. And so then Orange County says, no, we've got a law too. They come after you. And then the state of California says they come after me. And then the feds. What's the difference?
Yeah, so I think under that doctrine, the state has sovereignty. Counties and cities don't have sovereignty. So to the extent that any sovereignty is given to the city to prosecute offenses, it's delegated by the state to the city or the county. So any of those things that can really only happen once in the hierarchy, as opposed to the federal government is sovereign, the state government is sovereign. Now, the point that Gorsuch and Ginsburg raised and said, well, aren't the people sovereign? That's true, but we've delegated some of that sovereignty to those entities.
The real problem with these cases, I mean, when the federal government was drawing within its lines, you could have a dual sovereignty doctrine because there wasn't any overlap. you committed a normal crime that was in the state jurisdiction. The problem is the federal government, under a grossly expansive view of the Commerce Clause, has basically replicated the state's criminal code, and we now have a federal criminal code on every conceivable state crime. There's a federal parallel, and so the dual sovereignty doctrine that may have made sense a century ago makes no sense now. They get two bites at the apple, and that's why I wished that the court had gone the other direction on it. But that's a problem with over-criminalization and not drawing within the lines of actual federal authority.
I think I saw a hand in the way back. The microphone's coming over.
I have two questions. What is the jurisprudence of Justice Roberts and Kavanaugh on the Second Amendment? What are the prospects of the Supreme Court in the near term issuing a robust pro-Second Amendment opinion like McDonald or one of those? Second question is, what about the health and welfare of notorious RBG? I don't trust the news reports. It's hard to get reliable information. What are her prospects, if you have any inside dope?
Blood pressure, exercise regime, all that would be helpful.
Yeah, on the second point, I'll just say, I mean, that's what James Madison, I imagine, envisioned was happening when he's writing Article 3 of the Constitution, right? We're just going to watch the health reports of the justices on the Supreme Court on a daily basis to determine what we can do. No, I mean, I think it was a political misstep for her not to step down in 2013, and now there's consequences for political determinations like that. To the first point, I think Chief Justice Roberts joined in Heller and he joined in McDonald. So I think there's no question where he is. I think Justice Kavanaugh is likely to be in the same way, although that's speculation. I will say this, it's interesting to me, the Second Amendment was mostly a dead letter until Heller, right? And so most of these fights we've had about the Second Amendment and gun rights have been political. And in fact, we haven't had a decision really since McDonald. We've had sort of Justice Thomas writing separately on some concerns, but we haven't had a robust Second Amendment case since then. So this is sort of an invitation from the court to come up with this New York case and say, maybe we should have another serious discussion about what the scope of the Second Amendment looks like, other than you have the right to own a gun, you have a right to have it for self-defense. Well, what does that look like? When can it be taken away? What's sort of the state's interest in these cases? Now, again, as Professor Eastman points out, there's a good chance that the state of New York has invited the Supreme Court to kick this case, saying, no, we repealed the regulation. You can now transport it to gun ranges all over New York. And maybe that's enough to convince 5 justices to say, we don't want to talk about this. But I think this is a real opportunity for the court to consider it.
But I do think it is proof that they understand where both Roberts and Kavanaugh are. And Kavanaugh dissented from a case called Heller versus D.C., not the Supreme Court Heller decision. A subsequent one dealt with semi-automatic rifles, and he said, our sole job is to faithfully apply Heller. Now he's an intermediate appellate court judge at that point, not a Supreme Court justice. But the panel went the other direction, and he wasn't. So I think it's a good indication. It's certainly an indication that New York thinks there's enough there, that they're worried enough to change their law to try and avoid that ruling. We got a lot of issues. What standard of review? Does Heller and McDonald apply to gun ownership outside the house, or is it confined into the house? All these ways the lower courts, with the ACLU and these other groups, Brady and whatever, trying to minimize into nothingness the Heller decision, have been trying to do it. And they're desperately afraid that the court's going to say none of those efforts are successful. This is a personal right. It's guaranteed in the Constitution. It's a fundamental right. You get strict scrutiny, which means a lot of these regulations are not valid. And I think that's what they're afraid of.
Okay. Keeping our pattern of all the way in the front and all the way in the back so that our mic runner has to go a long way. I've got one. If anybody in the middle wants to ask a question, it might help him out on the Fitbit. Go ahead.
Yes. This may not be relevant here, but do you think the courts would consider rent control as the taking of personal property?
I certainly wish they would. So far, they haven't. One of my former students who went to Pacific Legal Foundation and now runs the Goldwater Institute in Arizona has been fighting that battle for quite a long time. It is absolutely a taking of private property for public benefit, or worse, taking from one private individual and giving to another. The thing that Madison said was the very definition of tyranny. And yet California is now putting it in place on steroids. So I'd like to see a legal challenge of that. I don't think the time is ripe for that yet, unfortunately. I wish it were otherwise.
Yep. Oh, here's a couple side by side in the middle.
I understand it's difficult to decide who's a citizen these days, I guess, from what I'm gathering here. But there seems to be a huge battle going on as to whether you can even have on the ballot a question as to whether, are you a citizen before you vote? Is that because there's some difficulty in deciding who's a citizen, or is there some ulterior motives here?
Yeah, I think like New York's attempt to repeal its statute because they can count to 5 against them on the Supreme Court, I think this is a fundamental notion that one of the major political parties in this country knows that they can't win on a. So if we expand the base, if we throw in felons, we get non-citizens voting, maybe we can hold on to political power. I'm shocked to know that there's politics going on. But look, San Francisco's just voted to allow non-citizen voting in non-federal elections, but they're not going to check for federal elections. So I'm hoping the Department of Justice is watching and understands that that's going to affect federal elections as well, and the voting rights section in the Department of Justice ought to be looking at that. Just a hint, but this is a huge problem. Look, it's not just raw political power. It's part of the broader. We'll tie it back into our morning panel. The broader multiculturalism fad, that there should be no such thing as nation state or sovereignty or borders, that will all be a multicultural utopia, worldwide kumbaya thing, and this will enhance liberty. Contrary to all evidence, that every time you get that much power centralized, it tends to do the opposite. But this is the push, and it's a push not just in the advocacy groups, but in major, formerly fairly serious scholars, saying that nation state and border and sovereignty questions themselves are violations of human rights, and this is a major trend in the international legal academy, and it's now playing out in these kind of questions. Yeah.
All right, we're going to have time for one more, hopefully, here, and then we're going to transition. Go ahead.
What restrictions, if any, do you believe there are on a United States District Court's authority to issue injunctions outside either the state in which it sits or the circuit in which it sits?
Well, I think they can. So you can imagine somebody. So imagine you own a patent, and you show up and you say, "Hey, this guy's infringing on my patent," and the court says, "You're absolutely right. Right? You have been your patent's been infringed upon. Nobody in the United States, that person can't go running around infringing your patent." And so if they're doing it in California, they can't run out to Florida. They can't run out to Maine. The sort of order applies in a sense nationwide. The real issue here when it comes to sort of nationwide injunctions is this notion that non-parties to the case, or people who have not been certified as class members of the case, or that somehow the court can extend that and sort of cover anybody anywhere. So when we talk about sort of nationwide injunctions, there's a lot of really nitty-gritty specifics we can get into about all the different ways that injunctions can apply nationally. But the real concern in these cases are California shows up and says, you know what, the Trump administration is not allowing California residents to get access to contraceptives under the Affordable Care Act. And a federal court sits there and says, you know what, that's absolutely correct. Residents of all 50 states, you now get contraceptives. I mean, it just makes absolutely no sense under any conception of Article 3 in terms of the power of the court to adjudicate the rights of parties before them. So I think that the geography is a concern, but I think it's often much more a concern about the parties and what the parties' interests are.
Yeah. Get the mic. We got the microphone still. Bring it all the way up.
Back to the front, happily. 10,000
You won't have to do
steps.
your exercise today.
Sorry to cause your exercise, but it sort of gets ignored that there are more than one way to get questions to come before the intermediate courts. Under the Administrative Procedures Act, when you're dealing with an agency's rulemaking and even sometimes their adjudications, it does not go through a district court. It comes directly to the Court of Appeals. And our decision there is not just the rights of the parties. It's a question of whether the rule was enacted legally or not. So in those cases, there's really no way to separate it down to our circuit. We are saying that that rule either is valid or it isn't. So that sort of gets lumped in sometimes as if we're trying to do the same thing as the nationwide injunction on an individual claim. But there is that category of cases that the decision has to be of national scope. Excuse me for interrupting. But
No, it's very. But by the way, this is one of the reasons why in our lunch chat with Judge Centel and I talked about the importance of jurisdictional doctrines and standing doctrines. In the Washington State case against the travel ban, Washington State argued on behalf of its university that they had standing because a lot of Yemeni terrorists would otherwise come to Washington State University and pay them tuition. Right. I mean, nobody asked them, well, when's the last time a Yemeni, attended Washington University, right? The standing claim was laughable. And yet, because the court wanted to reach this case, it ignored basic rules of judicial limitation on their power and issued it. So it's a much bigger problem of aggressive judicial resistance to an administration they don't like rather than injunctions. But it's playing out, and I think Supreme Court's going to do something about it relatively soon.
So I hope, like me, you both enjoyed the panel and learned a lot. Can we all take a minute to thank both our speakers and then invite Professor Eastman up to give remarks.
All right, I know we're running late and the booze is flowing downstairs, hopefully not on the floor yet, so we'll be real quick. Professor Wax said something at the very beginning, urging people to redirect their financial resources away from Harvard into institutions that are trying to save the Constitution. I can think of no better one than the Claremont Institute. So if you're interested... Christine Dominich is running around here. She can wave her hand and just find her. You've got a number of people in the room that have become fellow sponsors that sponsor one of our Publius or Lincoln Fellows or Martian Fellows in our summer programs. It's a great way to kind of help ensure that when we pass the baton to the next generation, they know what they're doing. Anyway, it's been a delight to spend the day with you, and I look forward to visiting with you all down in the reception room down on the lobby floor. And thank you again for coming, and thank you, Judge Centel, for joining us today.